In law of torts, there are three essential elements has to be required for person held responsible. First, there must be duty cast upon the person, breach of duty. Second, the third one is injury has to be done. The third essential elements has been analyzed by way of two major principles or maxims, what we call Latin maxims: Damnum sine Injuria and then Injuria sine Damnum. First, we can understand Injuria sine Damnum, and then later we can move on to the Damnum sine Injuria. Injuria sine Damnum means a violation of a legal right without causing any or loss or damage to the plaintiff. It is just reverse to the maxim Damnum sine Injuria. So that in every torts there must be injury has been done by defendant to the plaintiff. So that's why plaintiff has a right arises to sue defendant to claim unliquidated damages. So in this case, injuria sine damnum means injury without any damage. So first we have to understand what type of injury has to be incurred to the plaintiff. So in torts is very much essential this principle, and also the maxim injuria sine damnum has to be applicable, and also the person injured person has to claim compensation before the court of law. In this, injury means violation of legal right. Right we already know, so that's why everyone have a right to life, right to live, and then right to lead a life, and then everything they have some personal rights, and also the rights have been protected from the government. In this case, legal right is nothing but whatever right recognized under the law. So that will law we have everything for every law regulate the behavior of human. So that's why if any violation take place, or if any person injures to the other person, it amounts to violation of legal right without any justification, then is held responsible under the torts. For this we can analyze the case law Ashby versus White. This is famous case, and also in 1938 when the plaintiff was a qualified voter at parliamentary election, but the defendant, a returning officer, wrongly refused to take plaintiff vote. So that's why in this case a person approached the voting booth. He is a qualified voter, what we have registered, and then he has voter ID, everything, he has legal right. The returning officer wrongfully refused to take plaintiff vote. Later, the person who intended to cast a vote, he was won the election, but there is no loss to the plaintiff, was defended by the defendant. No loss was suffered by such refusal because the candidate for whom he wanted to vote won in spite of that. So that's why we must have to be analyzed in this case. Defendant was held liable. Why? Because action did not cause any damage, but it is violation of legal right. So that injuria sine damno, a loss suffered by the plaintiff, is not relevant for the purpose of cause of action. It is relevant only for assessing a number of damage. If the plaintiff has suffered harm and the wrongful act is actionable, nominal damage may be awarded. Let us analyze one more case, Bhim Singh versus State of Jammu Kashmir. In this also, Bhim Singh was an elected representative for the Assembly of Jammu Kashmir. He wanted to attend the session, assembly session, but government was house arrested him. He could not able to approach the assembly and cast his vote. Later he challenged the action done by the state of Jammu Kashmir, but Jammu Kashmir contends that due to the law and order, and also he costed against the decision, so that's why we house arrested him. But court held that he is a qualified voter, and also is a people representative, so that's why his right to come to the parliament assembly and then attend the session is his legal right. So that's why you are held responsible, and then 50,000 of damages has been ordered. So that's why first we understand injurious sine damne is nothing but there must be injury that has to be by way of violation of any rights. So that's why he not incurred any monetary damages or monetary loss. So that's why it's very much important. The next principle, damnum sine injuria, is very much opposite to the injuria sine damnum. So that's why in this case they must be opposite to the principle injuria sine damnum. It means damage which is not coupled with unauthorized interference with plentiful lawful rights. Causing of damage, however substantial to another person, is not actionable in law unless it's also violation of legal right of the plaintiff. So that's why we must have to understand it is very opposite to the injuria sine damne. There must be damage by way of loss to the person, but there is no violation of legal right. So that's why what we have in every transaction or in every act, there must be violation to place to the other person or breach of duty due to that incurred any loss. That's why we don't have any authority to challenge before the court of law. We can analyze, we can understand this by way of case law. The famous case, Gloucester Grammar School case. In this case, defendant had set up a rival school to that of plaintiff with the result that plaintiff were required to reduce the tuition fee of the school substantially. So there was an already plaintiff started school. Opposite to that, defendant started the school. Due to that, plaintiff school's admissions was decreased and then he incurred loss and then he sued the defendant. Due to setting up of school, I have incurred loss and then I have reduced the tuition fees. So that's why last year I got benefit, but this year I have incurred loss. So that's why due to your act setting up of new school, I have incurred loss. So that's why we must have to pay compensation. But the court held that plaintiff had no cause of action against the defendant on the ground that bona fide competition can afford no ground of action, whatever damage it may cause. So that's why we must have to be understand there must be damage by way of monetary or by incurred loss, but there is no violation of legal right. It has to be understand. And also in our cities and also in our villages, there must be a rival shops doing that. So one shop reduces prices and another shop also they incur loss, and then they will give more benefit and then more offer. The opposite shop also incur loss. So that's why there is no chance of setting. There's no chance of action against the other person. One more case we can understand: Mayor of Bradford versus Pickles. In this, what happened? Plaintiff has been caused maliciously. No action lies for the same unless plaintiff can prove that he has suffered injuria, that is legal violation of legal right. In this case, plaintiff had been deriving water from the adjoining land of the defendant, which was at a higher level. Defendant sank a shaft over his own land, which diminished and disclosed water flowing to the land of the plaintiff. So that's why in this also you have to understand there is two borewells setting up of what we have groundwater. One already is running, another is newly set up. Due to newly set up, the whole borewell was decreased its water level. So that's why challenge before the court of law due to your setting up of new borewell, I have incurred a reduce of water level. So that's why you must have to be pay compensation, or due to your act only I incurred loss. And one more case we can understand: Steamship Company versus Magru and Company. In this case, what happened? A number of steamship companies combined together can draw the plaintiff company out of the tea carrying trade by offering reduced freight. The House of Lords held that the plaintiff had no cause of action to defendant, had by lawful means acted to protect and extend the trade and increase their profit. So that's why everywhere business has to be done for only for getting profit, not by incur loss. So that's why without any what we called in consumer protection law, restricted trade practice, or any of the bad technique, or what we call hidden technique in trade. If you do that tactic, then you are held responsible under torts, but without any just with the justification, and then you do the business in your own way to get profits, and then there is no, if any person incur damages, you are not held responsible. So that's why injuria sine damne, there must be violation of legal right without any damage, but damnum sine injuria, there must be damage without any violation of legal right.